A very good afternoon, everyone. I'm Chirag Balyan, Assistant Professor of Law at Maharashtra National Law University, Mumbai. I'm delighted to welcome you at 6th Indian Review of International Arbitration, Distinguished Lecture Series on International Arbitration. And to grace the occasion, we have none other than Professor Hober, who is a leading and a highly regarded arbitrator, not just in Sweden or in Europe, but all around the world. Professor Hober holds a distinguished and a highly regarded reputation as a leading figure in the field of international arbitration. He has an experience of more than 3 decades. Take the name of any institution, be it SCC, ICC, ICSID, LCIA. He has done arbitration under almost all the rules. He represents both government as well as private parties in early 1990s. He was involved in the privatization matters in Eastern Europe, primarily in Russian Federation and Baltic states, which also means, not necessarily means, but he is bilingual. He can speak English as well as Russian. And during his time in the Russian Federation, Professor Hober worked as a legal advisor, which is equivalent of the privatization ministry drafting legislation and regulations for the privatization of state-owned enterprises, including in the oil and gas sector. I can keep listing down his achievements and accolades. There is no end to it. Professor Hober is a very famous professor at the Uppsala University, Sweden, and currently he's associate member with Verulem Building, 3 Verulem Building. So that's his introduction. And Professor Hober, it's a privilege to host you for the distinguished lecture. I think it's over to you. Kindly let me know when would you like me to present the PowerPoint, whenever you would want to use Article 31 and 32.
Thank you very much for this very kind introduction. I have been around for a while, as you could understand from it. And what I've been doing for now a number of decades is to be involved in investment treaty arbitration, both as counsel and as arbitrator. Now lately, since I retired from my firm about 7-8 years ago, I'm sitting mostly as an arbitrator, appointed by either respondent states or claimants, or also acting as chairperson. I have a few matters left as counsel, but my main activity nowadays is to sit as an arbitrator. And the title of my presentation today is Treaty Interpretation in Investment Treaty Arbitrations. So I will focus on the 2 core provisions of the Vienna Convention, which are Articles 31 and 32. And I will come back to them shortly. But before I get on to the Vienna Convention, I think it's helpful to put the whole idea, or perhaps system, if indeed it is a system, of investment treaty arbitration into perspective and in the proper context. As already the name indicates, investment treaty arbitration, these are arbitrations disputes based on a treaty, which automatically takes us into the sphere of public international law. And as many of you know, I'm sure, one of the cornerstones of any kind of, I would say, any kind of dispute in international law is the Vienna Convention on the Law Treaties, which I believe was adopted in 1969. Most, or at least very many countries have signed and ratified the Vienna Convention. Not all, but very many. Having said that, though, it is generally accepted, I submit, that the Vienna Convention codifies customary international law when it comes to investment treaty arbitration, when it comes to treaty interpretation, I should say, or the law of treaties. And if you will, to simplify things a bit, you could look upon the Vienna Convention as sort of the contract law of international relations, because nowadays, I mean, custom international obviously is critical, but public international law today is to a very large extent based on treaties. So the Vienna Convention is, as I said, absolutely essential for any kind of activity, I would say, in public international law today, and that includes investment treaty arbitration. And as many of you know, there are many other extremely relevant and important provisions in the convention that do not concern interpretation. I'm not going to go into those, but simply focus on Articles 31 and 32. So whoever gets into investment treaty arbitration should have a sound understanding and deep knowledge of the Vienna Convention, certainly when it comes to interpretation of treaties. The other, in my view anyway, the other really basic international instrument when it comes to investment treaty arbitration is what we call the ILC, International Law Commission's Articles on State Responsibility. Some of you may be familiar with this document. It is not a treaty, it is not a convention, but it is a document produced by the International Law Commission, which, as you probably know, is well, it's not formally, I suppose, a UN body, but it's a group of scholars, public international law scholars, working under the supervision, if you will, of the UN to codify and develop public international law. And about 10 years ago or so, or probably more than 10 years ago, they finalized their work on the Articles on State Responsibility. At that point in time, they were called the draft articles, but they have since been adopted, if you will, by the UN General Assembly and recommended to countries, to states, to use these articles. And now they're referred to as articles simply, ILC articles. And from our perspective, from an investment treaty perspective, the most relevant provisions of the ILC articles are the rules of attribution. And I'm not going to talk about the details there, but the rules of attribution generally guide us in trying to determine what acts of a state entity, or indeed of any kind of entity, private or official or public, are to be attributed to the state for purposes of state responsibility. So this is, if you will, the first step in analyzing state responsibility, i.e. determining whether or not the acts in question are in fact to be attributed to the state, such that the state may be responsible for them. But the second step, the responsibility of the state, does not concern the rules of attribution, but that analysis deals with other aspects of the articles. So those two documents, the Vienna Convention and the ILC articles, are essential to understand what's going on in investment treaty arbitration. As many of you probably know, in a typical investment treaty case, on the respondent side, the state is obviously always the respondent, but there may be other entities in the host state which are publicly owned or maybe partially publicly owned that are alleged to have done or not done certain things. So the issue will then arise whether or not the activities of those entities, are they attributable to the state or not? So that's the first step of the analysis. A couple of other general comments I think are worthwhile here when it comes to investment treaty arbitration. As I've already hinted at, the governing law, if you will, of any investment treaty dispute is in fact public international law, because the treaty is a result of public international law. So at the end of the day, the tribunal, the decision makers, will always have to decide the case based on public international law. That does not mean that municipal law is irrelevant, and I will come on to that in a second, because it is relevant in certain respects, but it's never the governing law in a sort of legal technical sense. It's also important to remember that, and this is a defense which some respondent states still try to run. They say, whatever we did in full compliance with our own legislation. This is a new law passed by our own parliament, so we have only done what we're entitled to do under our own legal system. But under public international law, municipal law can never be a defense against violations of international obligations. So this is a hard pill to swallow for many politicians, I have found. But if you think about it, if you could get out of a public international law or international obligation by simply referring to your own legal system, that will mean the complete collapse of public international law as a system. So this is important to keep in mind. And as I said, it's not so difficult for lawyers usually to understand this, but more politicians have a hard time to do this, to accept this. Also, another very fundamental aspect here is the fact that when a state signs a treaty, that by definition means that it gives up sovereignty with respect to those issues covered by the treaty. Because as some of you, I'm sure, know, there has been a lot of criticism about investment protection treaties, saying that they involve an infringement upon the sovereignty of the state and so on and so forth. Yes, of course, that's the whole purpose of signing a treaty, that you as a state, you agree to abide by the treaty, which as a consequence means that you have given up certain degree of your sovereignty. And that's, I mean, this is basic stuff and simple in my view, but sometimes forgotten in the debate about investment treaty arbitration. Going back quickly to the role of municipal law, as many of you know, you've probably seen a number of investment protection treaties, the bilateral ones, for example. They have usually quite detailed definitions sections. And one thing that is always defined in these sections is the concept of investment and the concept of investor. And very often, a jurisdictional objection is raised by the respondent state to the effect that the claimant is not an investor or has not made an investment. So this is an issue which tribunals will have to deal with early on, usually. In many definitions, let's say, of investor, the definition will be something along the following lines. An investor is any legal entity incorporated under the rules of the country where it is supposed to be incorporated. So an Indian company would be deemed to be an investor in such a definition if it has been incorporated in India, observing the Indian rules for incorporation. So you see there's a reference to municipal to local law. But at the same time, when this argument is raised as a jurisdictional objection, the tribunal will have to deal with this as from a public international law point of view, i.e., as a question that must be interpreted based on the text of the treaty. So, but I should say, in doing so, the tribunal will have to take into account what Indian law, in my example, says about incorporation of legal entities. But it doesn't mean that the tribunal can actually apply Indian law, but it applies public international law, taking Indian law into account. And we usually say you take it into account as a fact. So you see here the interplay between public international law and municipal law. But I think it's important to keep in mind that whatever the tribunal does in a situation like the one I described is an exercise of public international law, where municipal law plays a certain role. I mean, there are some older bits bilateral investment protection treaties where the parties have, I have to say, against better judgment, included references to municipal law as the applicable law. Yeah, I mean, that usually only creates problems. And because depending on exactly how the wording is, it may be very difficult for a tribunal properly to understand and interpret what the parties actually intended by such language. Because at the same time, in most cases that I've seen anyway, they have not ruled out the application of public international law. So somehow the tribunal will have to reconcile the idea of applying municipal law and public international law at the same time, which is usually quite difficult, I have to say. Well, that was a long introduction, perhaps, but I think, from my perspective, a necessary one before we get on to Articles 31 and 32. And maybe you could show them now on the screen. Yes. So we have, there are two basic provisions, as I said, in the Vienna Convention. It's Article 31, which is called the General Rule of Interpretation. And as you can see, if you scroll down a bit, it has 4 parts. Yes, the fourth and last one referring to a special meaning and so on and so forth. But the general idea is that anyone who sets out to interpret a treaty provision should go through, or I should say, should take into consideration all these four aspects of Article 31 before we can say that the interpretive exercise has been completed. So when I say take into account, it doesn't mean that each and every one of these four elements, so to speak, must be applied, if I use that word, but the interpreter must take them into account. And I will come back to each of them shortly. But before I do that, let's take a look at Article 32. If you could show that, please. And that is, as you can see, referred to as supplementary means of interpretation. And there is a hierarchy here between Article 31 and 32. You should always start out with Article 31. And 32, you may, as the language says, you may have recourse to that under certain circumstances. So it's a subsidiary rule in comparison to Article 31. If you go back to the top, please, to Article 31, yes, and to item 1. Before I come on to Article 31, let me also make clear that even though there were some discussions at one point in the investment treaty arbitration context of whether or not the Vienna Convention was in fact applicable at all, because public international law is supposed to be, according to that view, issues between two states, and the Vienna Convention really should be limited to issues between two states. And of course, in an investment treaty arbitration, you have a private, if I may say so, claimant, and not a state, but a private claimant against the state, a respondent state. And the argument went really that, the Vienna Convention is not really adapted to these kinds of situations. I think that debate has faded away. So it's now generally accepted that whenever you need to interpret an investment protection treaty in this context, you go to the Vienna Convention and you go to Articles 31 and 32. So I will walk you through Article 31 and the different aspects of it fairly quickly, I think. You can spend a lot of time on this, but my ambition here is to give you a general idea, a general sense of what is involved in treaty interpretation. And the main rule you find in paragraph 1 or in item 1. And as you can see from the text, that paragraph contains 4 elements. A treaty shall be interpreted in good faith. That's the first element, good faith. In accordance with the ordinary meaning. And that's the second element, ordinary meaning to be given to the terms of the treaty. In their context, which is the third element. And the fourth one, in the light of its object and purpose. So these 4 elements are basic elements, if you will, in treaty interpretation. It's important here to keep in mind that none of these 4 elements is more important than the other. So whoever interprets a treaty needs to take into account all 4 elements before you have sort of completed the exercise prescribed in item 1. Now, needless to say, in practice, you start with the language, you start with the ordinary meaning. But that is not the end of it. You need to go on and look at the other three elements as well. And I think, again, from a practical point of view, the good faith requirement is not, it doesn't create much debate or discussion. And you seldom see views on the good faith aspect here. I mean, one example could be perhaps if a party who knows that a certain intention lies behind a certain expression, but if that party knowingly tries to have the other side or a tribunal believe that it actually means something else, I mean, that would probably be a violation of the good faith idea in Article 31.1 of the Vienna Convention. But the other three, so good faith is usually not a problematic aspect of Article 31.1. But the other three, ordinary meaning, context, and object and purpose, are sometimes more critical and more difficult to deal with. If we start with ordinary meaning, very often you will see in awards, at least, that the first port of call for many tribunals is to look at the dictionary. What is the lexical meaning of this and this word, this or that word? I mean, that may be a starting point, but it's almost never the finishing point, so to speak. You need to look at the ordinary meaning, as the text says, in its context and in light of the object and purpose of the treaty. So just to give you an example of a real-life example, in fact, I was involved in a case many years ago where you had in the definitions section of the treaty clear definitions of a national of the contracting parties as an investor, and of corporations or companies also as investors of under the treaty. And these two concepts, national and company, were used throughout the treaty in different ways. In the actual arbitration clause, reference was only made to nationals. So in essence, if you read the words of the arbitration clause, it meant that only nationals could start an arbitration, alleging that a violation had taken place under the treaty. But it seemingly then excluded companies as investors or as participants in a dispute. So the respondent state, of course, because the claimant was a company then, so the respondent state tried to argue that, look here, it's only open, it's only available to nationals, and it's clear that this company is not a national as per the definition in the treaty. So what the tribunal did then was that we looked at the term, the ordinary meaning of the word, which was pretty clear, but we also looked at the context in which company and national were used. We also looked at the object and purpose of the treaty. And we came to the conclusion that it would not be, I mean, our interpretation based on 31.1 was that a company must be included or must be covered by the arbitration clause in that particular treaty. Which I think was not a difficult conclusion to reach, given the circumstances of the case. So we analyzed that the two words company and national then, and looked at the context in which these two concepts were used throughout the treaty. We looked at how these two concepts were used in other provisions. We looked at some of the headings of the treaty under which these two concepts were used. We also looked at the object and purpose of the treaty, which, generally speaking, when it comes to investment protection treaties, one object and purpose is clearly to protect foreign investments of both nationals, we said, and companies. So the context and object and purpose in our case led us to this conclusion that companies must be included in the arbitration clause. The object and purpose, which is referred to in 31.1, you will, in many investment protection treaties, you will find the object and purpose defined or described perhaps in the preamble of the treaty, but also throughout the treaty in other provisions. And the provisions, all of them taken in a totality, could also give the tribunal an idea of what the object and purpose of the particular treaty is. So that's the first, and from a practical point of view, the most important rule of interpretation, which you find in 31.1. And then it goes on in 31.2 and 3, and will give the interpreter, so to speak, whoever interprets the treaty, a more detail about what the terms mean in 31.1. So in 31.2, as you see, it defines the context referred to in 31.1. So the context includes, in addition to the text, as I mentioned, and the preamble and annexes, in item A, any agreement relating to the treaty which was made between all the parties in connection with the conclusion of the treaty. So as you can see, it's quite precise. So it's a treaty, or agreement between all the parties to the treaty in connection with the conclusion of the treaty. So it's not any old agreement between some members of the treaty. So, and of course, you are probably familiar with these kinds of agreements, which parties, for various reasons, decide to enter into, but not to include, so to speak, in the actual treaty text. But such agreements then do form part of the context for purposes of interpreting a relevant treaty provision. And item B, as you can see, refers to any instrument, i.e. not necessarily an agreement, but any instrument which was made by one or more parties in connection with the conclusion of the treaty and accepted by the other parties as an instrument related to the treaty. So again, it's not an agreement, but it's a statement or announcement made by one or more parties in connection with the conclusion of the treaty. But and this is important, it must be accepted by the other parties as an instrument related to the treaty, which the language of item B actually excludes what we usually refer to as unilateral statements of how the treaty is to be, or a provision is to be interpreted. So that individual statements are obviously fall under item B, but they also have to be accepted by the other parties as a proper, if you will, statement concerning that treaty. So if we move on then to, if you scroll down and move on to item 3 of Article 31. So here you have a further definitions, if you will, or guidelines for the interpreter of the treaty. Item 3 says that in addition, or together with the context, other agreements and practices may be taken into account, or rather shall be taken into account. Item A then deals with a subsequent agreement concerning the interpretation. So again, it has to be an agreement between the parties regarding the interpretation. Again, not a unilateral or one-sided statement of sorts. Item B refers to any subsequent practice in the application of the treaty, which establishes the agreement of the parties regarding its interpretation. So again, you see the language is quite precise. So it's not any old alleged practice in the application of the treaty that falls under item B, but it has to be a practice which establishes the agreement of the parties on how to interpret the treaty. So, I would say item B obviously entails quite a lot of problems or burdens when it comes to evidence. How do you establish this practice? I'm not sure that I'm aware of any situation where this has been successfully argued or successfully established. And the third element of item 3 is any relevant rules of international law applicable in the relations between the parties. Again, a very wide description of what could be relevant. And to what extent this is the case in a given situation will, of course, very much depend on that situation. So it's difficult to describe more in detail in the abstract what this would mean or could mean. The important thing here, especially with respect to item C, is to remember that this is a rule for guideline for the interpretation of a treaty provision. Item C in 3 does not allow the interpreter to replace a treaty provision with another rule of international law that may be applicable. So it's said maybe in the relations between the parties. So this is simply to assist a tribunal or a court in interpreting a provision of the treaty. So sometimes I get the impression that counsel are trying to use 3C as an argument to try to replace a rule of law which is maybe otherwise applicable based on Article 3 or item 3C. But that's not the function of item C, but simply to be of assistance to the tribunal or the court who is trying to interpret the provision in question. Item 4 then, a special meaning, and this should be read as special meaning as opposed to ordinary meaning, in 31.1, a special meaning shall be given to a term if it is established that the parties so intended. From a practical point of view, in investment treaty arbitration, this item 4 is not very often relied upon, simply because, as I mentioned before, most investment protection treaties do have quite detailed definitions sections, which means that is usually Article 1 in a bilateral investment protection treaty, and that is already part of the treaty text and will be interpreted as such. So this is intended for other situations where a term that has not been defined in the treaty but seems to be used in a certain way by the parties, which then has another meaning than the ordinary meaning of the word. But as I said, from a practical point of view, it doesn't play much of a role in investment treaty arbitration. Now, if you move on, then, oops. Can you still hear me?
I can hear you, sir.
Okay, very good. I disappeared from the screen for a second. I was a bit worried. Okay, if we move on then to section 32, please. As I mentioned at the outset, this is referred to as supplementary means of interpretation. So it comes into play really when the interpretive exercise under Article 31 has not yielded any clear results, if I put it that way. And it's subsidiary, as I mentioned also before, and it's illustrated by the word may. Recourse may be had to supplementary means of interpretation, including the preparatory works and the circumstances at the conclusion of the treaty. So preparatory works and circumstances at the conclusion of the treaty are examples of supplementary means of interpretation, and it's not exclusively limited to those two items. And I will come back to that in a second, but let me mention just a few words about preparatory works. Because as you will have understood by now, I mean, interpreting a treaty is quite different from interpreting a contract. And in many jurisdictions, when you interpret contracts, you look at maybe negotiations and what has been said and done before and so on and so forth, i.e., which would correspond maybe to the preparatory works of a treaty. And in many cases, counsel focus quite a lot on the preparatory works in order to convince the tribunal of this or that interpretation of a treaty term. But as you can see from Article 32 and its placement as a subsidiary rule, the preparatory works comes in at a fairly late stage, or should come in at a fairly late stage of the interpretation of a treaty. And on top of that, as many of you I'm sure know, preparatory works are tricky because very often they consist of parties expressing positions and taking positions, and rather seldom do the preparatory works actually present an agreed interpretation or a unified understanding of certain issues or certain questions. So it may be helpful for counsel to use them in presenting their arguments, but for the tribunal having to interpret the treaty. In my view, I have to say, in my experience, it's usually not very helpful. But I mean, you as counsel, you obviously will have to look at that and see what you can do with it. But from a strictly objective treaty interpretation point of view, I think it's usually not very helpful. And the other element referred to in Article 32, circumstances of at the conclusion of the treaty. Again, I mean, needless to say, it depends very much on the situation at hand. But sometimes, that is a relevant factor which may or maybe should be taken into account when interpreting a treaty. There is a rather well-known example of this in one of the early cases, Plama versus Bulgaria, where the tribunal actually took that into account, because that bit, bilateral investment protection treaty, was signed by Bulgaria at a time when Bulgaria was part of the, well, let's call it the Soviet Empire in Eastern Europe. And at that time, countries from that part of the world had arbitration clauses which were, they said anyway, restricted in their application, and allowed arbitration only in certain circumstances. So when the tribunal was asked to interpret the arbitration clause, they took into account that at the conclusion of the treaty in question, Bulgaria was part of the communist system, in which these kinds of arbitration clauses were said to prevail. So that was one element which that tribunal took into account. The other supplementary means of interpretation, which comes from using the word including, would include, in my view, other, let's call it rules or what, rules of interpretation or methods of interpretation that we're all familiar with, like lex posterior, a later law trumps an earlier one, lex specialis, for example, principle of effectiveness, effet utile. I mean, you need to interpret, which means you need to interpret a treaty term in such a way that it has a meaning. And there are other, very often Latin maxims covering different approaches to interpretation, not only of treaties, by the way, but very often of contracts too. But those are also part, in my view, of the supplementary means of interpretation. But again, I stress again that these other rules or approaches to interpretation are subsidiary to Article 31. Another important thing to remember with Article 32 is that it's intended to be used only in two situations, as you can see from the text. Either to confirm the meaning resulting from the application of Article 31, not to change, in other words, but to confirm the meaning. That's the first area of application, so to speak, for Article 32. And the other one is to determine the meaning, when the interpretation according to Article 31 is either leaves the meaning ambiguous or obscure, or leads to a result which is manifestly absurd or unreasonable. So it's only in these two situations where you can actually resort to Article 32. And even in the second instance here, when Article 32 speaks about determine the meaning, it's still, and I've emphasized this again, it still talks about the interpretation according to Article 31. So you need to, if you end up in Article 32, you still need to relate to the interpretation resulting from Article 31. So it's not like Article 32 is an invitation to do completely new interpretation of the treaty term in question. So it's a bit more tricky than that. Well, I've been going on now for 50 minutes or so, I think. So I think it's probably time to stop there. Let me just say this by way of conclusion, that as you will have understood from my presentation today, it's a bit more complicated to interpret treaties than contracts, generally speaking. And I think one of the problems we had in the investment arbitration world in its early days was that many, or too many anyway, in my view, tribunals were not really aware of, or didn't want to be aware of, I don't know, that there is a difference between contract interpretation and treaty interpretation. But I think nowadays, I mean, most tribunals have learned how to interpret treaties and not treat them as contracts. I mean, in many jurisdictions, when you interpret contracts, you look at the common will of the parties, and it's expressed in different ways. But I think the bottom line very often is the common will of the parties. That does not play such a leading role, if any role at all, in treaty interpretation, except that the view is that the common will of the parties is paramount as expressed in the language of the treaty. So I think that's the trick in trying to reconcile the two approaches here. So going back to Article 31.1, the actual words, the language is important and certainly the starting point, but at the same time, not the only thing you look at in Article 31. Well, I think that was it for today. I mean, I could go on for quite a bit more, but I think that's enough for today. And I'm happy to take any questions if there are any, or comments. Thank you very much.
Thank you, Professor Hober, for the insightful lecture. So, first question pertains to most favored nation clause and the term context. Clause 1, treaties must be interpreted in their context. So, it is in this background how justifiable it is to use MFN clause to borrow a provision from other treaty.
Well, I mean, I'm not going to answer that question because I cannot. I mean, it cannot be answered in the abstract, quite frankly. I mean, you need to look at, I mean, we'll talk about MFN clauses in a generic way, but they're all different.
Right.
So, I mean, you need to look at the text of the actual MFN clause to start to understand how to interpret that clause. In that MFN clause, or in many MFN clauses anyway, you will find references to other clauses in the bit as well. So you need to look at those as well. So, I mean, it's not, you know, it's not possible to give an answer to that question in the abstract. Having said that, though, I think MFN clauses, you can debate whether or not they make sense in a general way in investment protection treaties, but in trade treaties, I mean, the idea behind an MFN clause is, as far as I understand, simply to be able to benefit from other provisions in other treaties, which are deemed to be more favorable than the provisions in the treaty that you're looking at. So, I mean, the nature of an MFN clause is to jump from one treaty to another. Whether or not that is always desirable or should always be the consequence of an interpretation of a specific MFN clause, as I said, you can't really say in the abstract.
Thank you for your response. Second question pertains to customary international law. Say there's a provision in the treaty or there is no provision in the treaty about exhaustion of local remedies, but then there's always an argument that it is a rule of customary international law that local remedies must be exhausted. Now, in that circumstance, which rule of interpretation of treaty we are applying? Because if we go by the literal language of the treaty, there is no exhaustion of local remedies. An investor must be directly able to use ISDS. So, which rule do we apply?
Well, I think again, I mean, one has to look at all these provisions individually against the background of the case, of the individual case. But I would say that in those bits where you have an arbitration clause, and there is no mention in the arbitration clause of the need to exhaust local remedies, or there is no mention otherwise in the treaty of the need to exhaust local remedies, I think it's fair to say that the general held view today is that you don't need to exhaust local remedies, but you can go to arbitration. But I say that with a reservation that you need to look at the arbitration clause in question, and then you need to look at the bit in question. And I think this debate, which might have existed in the investment treaty world at the very beginning of the investment treaty arbitration era, if I may call it that, but I think it has more or less faded away. And I'm talking about a situation where you have a traditional arbitration clause in the treaty, but nothing mentioned about exhaustion of local remedies in that treaty. So I think the theory behind that thinking is that the parties have directly, or maybe rather indirectly, agreed not to require exhaustion of local remedies.
Thank you for your response. Another question is, when a tribunal apply the decision given in another investor state arbitration in order to interpret the treaty provision in the case at hand, so how do we reconcile such interpretative strategies?
I'm not sure I understand the question, but
my question is use of precedent in investment arbitration.
Well, I mean, strictly speaking, and that's another important feature of public international law, including international arbitration, there is no such thing as stare decisis. I mean, there is no principle of binding precedent. So every tribunal is free to do what it wants, to put it in simple terms. You're not bound by any other by any decision by any other tribunal. So when I sit as an arbitrator, I would not simply, without more, rely on what another tribunal has done in terms of interpreting a treaty. I think that's a bit abdicating from your role as a decision maker in your own case. I mean, that doesn't mean that you shouldn't or couldn't look and take into account what others have done. I mean, we all do that in different ways. And if for no other reason, because the parties will usually have relied on other cases in support of their respective arguments. But as a decision maker, as an arbiter, you have to take your own decisions. So I would not recommend, relying exclusively on what someone else has done.
Thank you. Before we take questions from the chat box, is there anyone who would like to directly pose a question to Professor Hober? You may please raise your hand. Else I'll proceed taking questions from the chat box. Okay, so Professor, while people ready themselves, let me take questions from the chat box.
Mm-hmm.
Sujaya has raised her hand. Sujaya, allow me to unmute you. Give me a moment. Yes. Now you will be able to unmute yourself.
Good
Please.
evening, Professor Hober.
Good evening.
Trust you're doing well. So my question is on Article 31(3)(c) and sort of the importation of sustainable development obligations and environmental law treaties. So how would the interplay between them and obligations under investment treaties, how do you expect they would work going forward?
Well, as I said, you have to be careful with that particular provision because it's only a guideline for interpretation. It's not that you can replace the treaty in question or a treaty provision in question with references to other principles or rules of international law. It's only for interpretive purposes. So it's not an invitation to just argue that we should apply this and that convention instead of instead of the BIT. That doesn't mean that you cannot run arguments like that, so to speak, for purposes of interpretation, but you cannot. It's not a gateway to sort of change the contents of the bit in question. And needless to say, I mean, where do we? And I've not come across anyway situations where it becomes really critical. But of course, you can see that at some point you may have a difficulty in distinguishing between what I just said. I mean, what is interpretation and what is something more than interpretation. So there may be other examples. There may be examples out there that I'm not aware of, but I mean, some particular respondent states, I have to say, have jumped on this provision, hoping that it could use it to change the game or the dispute. But in my view, that's not the purpose of this provision. It's simply to help, again, whoever is trying to interpret the treaty.
If I may add a brief follow-up question, Professor Hober, with states trying to include the legal fiction of investor obligations into treaties, whereas we know that investors are not the subject of international law. How do you believe this could be reconciled through the provisions of Articles 31 and 32 of the VCLT?
I'm not sure I understand the question, but I mean, one other basic aspect, and this comes up in quite a number of disputes, is that, at least in my view, and I think most other commentators would probably agree with me, that I mean, you cannot read into a treaty something which is not there. I mean, you can only interpret what is there in the treaty. So, I mean, to give you an example, and this is an old example, going back to the definition of investor, in many bits, and this is now changing from time to time, but in many bits, you have a very simple definition of investor. Any entity which is lawfully incorporated in one of the contracting parties. Full stop. No further requirements, not as to ownership, financing, beneficial owner, ultimate beneficial owner, and so on and so forth. And one of the early cases in the investment treaty era was a case between a Lithuanian investor and the Ukraine. And the Lithuanian company was owned, if not 100%, 99% by Lithuanian and by Ukrainian citizens. So the Ukraine, of course, said, you know, these are not foreign investors, these are Ukrainian guys. I mean, they have no right to fly under the protection of the BIT. And the chairman of that tribunal, sadly now deceased, but very well-known name in as it was called in those days, the state contract debate. He wrote a very, I would say, angry dissenting opinion, saying that, I mean, this was not the purpose of these treaties, and so on and so forth. But the other two, the party appointed arbitrators, said, sorry, but I mean, the treaty says this, and we cannot read into the treaty any other requirements that we find there. And this language or similar language has been repeated in many cases where respondent states try to read into, typically respondent states try to read into the treaty requirements which are simply not there. And I mean, that's why we're seeing and have seen for some time states renegotiating bits, modernizing them, making them more detailed, and so on and so forth. But if the treaty doesn't require that the majority of the ownership is from a foreign country, or if the financing of the company should not come from the host state, and so on and so forth, I mean, it's very little you can do as an arbitrator. And I think the same goes when you talk about investors' obligations. Unless there are investors' obligations in the treaty, it's difficult for a tribunal to read that into the treaty. Now, I suppose the other side of that coin, in a way, is that, well, if the investor has somehow misbehaved, or whatever, I mean, there are usually remedies in municipal law to take care of that, because the investor will usually have incorporated a local company. And if the allegation is that the local company has violated local law, well, I mean, you have a remedy there in local courts.
Thank you, Professor, for your answer. If you permit, can we take two more questions?
Sure.
So Mr. Vikas, he asked the question, Do you think investment treaty obligation can supersede public policy expectations of any country?
I'm not sure I understand. Well, I think the short answer is yes, because it follows from what I said at the beginning that, municipal law in different shapes and forms can really never trump international obligations. So if a public policy expectation is expressed in municipal legislative form, and it runs counter to an international obligation, the way the system works is that international law trumps municipal law. Of course, there is another aspect to this, and that may be the gist of the question, but when we come to the well-known fair and equitable treatment standard, one key aspect of that, of course, is legitimate expectations of the investor, which is often contrasted with the legitimate interests of the state to regulate its own economy. And of course, there again, both approaches are correct. I mean, an investor does have legitimate expectations, generally speaking, of different kinds depending on the situation. But also the whole state, of course, has the legitimate right to organize its own economy and regulate its own economy. And the difficulty here, as we've seen over the years, is to find and draw the right balance. And again, in my view, I mean, there is no easy answer here, and the answer will have to depend on the circumstances of each individual case.
Thank you, Professor, for your response. Next question is from Palak. Palak asks, how often are investment treaties affected by material change doctrine in real life?
Material change doctrine. You mean in relation to the treaty's application, or I'm not sure I understand.
If I could explain it a little bit, what I mean is by material change doctrine, I mean if the circumstances of the states have changed to such an extent that when they entered the treaty, the intention could not be executed because of that particular material change, essentially.
Okay, so, I understand. Well, that's a difficult and thorny topic, I would say. I mean, if you look in the Vienna Convention, there are provisions dealing with changed circumstances and the like. Generally speaking, the approach taken in the Vienna Convention is rather strict. And when it comes to the interpretation of the treaty and what the meaning of different provisions of the treaty should be, the starting point, according to the traditional approach anyway, is to look at the situation when the treaty was entered into, i.e. subsequent developments are not necessarily important in that respect. And I think, I may be wrong, but I think that is still a prevailing view, certainly in the investment treaty sphere. But I don't know if you're familiar with the European Court of Human Rights in Strasbourg. I mean, they have embarked since many years on a very, according to many observers anyway, a very liberal interpretation of treaties and adapting that treaty, the European Convention on Human Rights, to subsequent developments to try to take into account of what has happened in real life, so-called evolutionary approach to treaty interpretation. So there are certainly different views about this, but I think the traditional / conservative approach would be to say that subsequent events, yes, may affect not so much the interpretation, I think, of a treaty, perhaps, but certainly the effect and the application of a treaty. But still, again, based on the rules and provisions of the Vienna Convention.
Thank you, Professor. We certainly have some more questions, but in the interest of time of each one of us, we should formally close the question and answer session. And on behalf of Maharashtra National Law University, Mumbai, Center for Arbitration and Research, Indian Review of International Arbitration, our supporting partners, Young MCIA, SCC Online, Eastern Book Company, we would like to express a deep felt gratitude for the most enlightening lecture you have delivered today. It was our privilege to listen to you, and in future, we would look forward that you can come to Mumbai and interact with us one-on-one, and the pleasure would be ours. Thank you so much, Professor Hober, for your valuable time and sharing a toolkit on how investor-state treaties must be interpreted. I'm very sure any person who just hear this lecture would know, how to navigate complex treaties, how to interpret them, what to do and what not to do. So thank you for this masterclass.
Thank you very much. My pleasure.
So we will close this session now. Thank you, everyone,
Thank you.
for your patient listening.
Thank you. Bye.